Good afternoon, everyone. I see that our attendees are trickling in, so I'll do a couple introductions and thank you so much for joining us. My name is Marissa Choi, and I'm an environmental and energy attorney in Los Angeles. I currently practice as a regulatory attorney at Southern California Edison in-house. So today's topic is very relevant to my day-to-day. I'm pleased and delighted to introduce Peter Allen and Jason Sanders, who will be presenting today's session on navigating proceedings before the CPUC. On the next slide, I'll just give you a little bit of background about our organization that puts on this series every summer. So the California Lawyers Association is a nonprofit, all-volunteer organization that was formerly part of the state bar. Within CLA, there are multiple sections covering different topics and practice areas. One of those is the new lawyers section, and that's available to all folks who have recently passed the bar and are in their first 8 years of practice. Jason and myself, we are members of the executive committee for the environmental law section. And as part of the programs, we put on MCLEs, webinars, conferences. For the past several years, we have hosted a series of free Zoom 101 sessions on kind of basic practice areas within environmental law. And so I will let Jason introduce himself and tee up kind of what to expect for the rest of the summer. Thank you.
Thanks, Marissa. Yes, my name is Jason Sanders. As Marissa mentioned, I'm an executive committee member for ELS, and I work for Vinskus and Associates. We are a small private law firm that does public interest litigation, environmental. We do some housing rights, and we also practice before the PUC. So I'm very happy to be able to get Peter to provide this session for us today. I will be interested in everything he has to say as well. And in terms of the upcoming Environmental Law 101 series, we have, of course, today's session, but we also have some sessions coming up in August. And one of those is going to be the managing CERCLA liability and real estate transactions, and Fahrenheit 101, one that I'm very interested in regarding climate change law on August 21st. And then we have the pre-Yosemite conference networking tips and tricks. That will be to be determined sometime in September or October. And then the very popular environmental law conference at Yosemite, which takes place on October 16th through 19th. And I would encourage everyone to be on the lookout for registration for that. Don't want to miss that. And now I have the great pleasure to introduce Peter Allen. From 1991 to 1992, Peter represented the city of San Diego and its residents in energy and telecommunications proceedings before the PUC. From 1992 to 1995, he worked for the utility consumer group, TURN, representing residential and small business customers in gas, electric, and telecommunications proceedings at the CPUC. In 1998, he went to work for the PUC first as an attorney and then later as an administrative law judge. As an attorney, he did both advocacy and advisory work on a wide range of issues. And as an ALJ, Peter presided over a range of high-profile energy proceedings, including allocation of $30 billion of energy crisis electricity contract costs, implementation of RPS, and retirement of the Diablo Canyon nuclear power plant. Peter retired in 2022 and has subsequently been working with a nonprofit providing training to Southern California tribes on how to litigate at the PUC. And with that, I am honored to turn it over to Peter Allen.
Thanks, Jason. Thanks for the intro. Just as some background, I previously last year, I did a presentation through the Conference of California Public Utility Council, the CPUC, which is the organization for attorneys who practice before the PUC. They don't do a lot of programs, but they do a few programs, all related to PUC practice. They have an annual conference that's quite good. And if someone is a regular practitioner or thinking of being a regular practitioner, I would encourage you to check them out. As Jason indicated in the intro, I've been doing some work under the Tribal Energy and Climate Collaborative, and been offering trainings to some Native American tribes. That's through the Southern California Tribal Chairmen's Association. And so that's, there's been invitations out through to this one as well. So for representative tribes to participate. This slide has a lot of words that I'm not going to read. It basically says that the tech program under which I'm doing the training was funded by some grants by the PUC. So with that, I'm going to jump right in.
And Peter, just before you start, I just wanted to mention for everyone listening in, this is being recorded and it will be available for free on our website. And then CLA will also make available the PowerPoint slides, the PDF. So if folks have to drop off, we'll leave some time for Q&A at the end, and folks can enter questions in the Q&A function at the bottom of the Zoom screen. So thank you so much. Well,
cool. Thank you.
Yeah.
Thanks for doing that. Yeah, I'm going to kind of try and blaze through a bunch of stuff just because the amount of material and the limited time. So not going to do a lot of history or theory, just a lot of nuts and bolts of how things work. And hopefully this will be useful. The CPUC is the California Public Utilities Commission. It regulates investor-owned utilities in the state of California. It does not regulate publicly owned utilities, utility districts. LADWP, SMUD, East Bay MUD, Imperial Irrigation District, et cetera, are not regulated by the PUC. On the energy side, you know, PG&E, Southern California Edison, SoCal Gas, San Diego Gas and Electric are regulated by the PUC. The PUC regulates multiple industries, not just energy. There's also telecommunications, investor-owned water utilities, certain types of transportation, and rail safety. The way those industries are regulated may vary. So what I'm going to be focusing on today is for energy utilities. Much of what I say will apply across industries, but not all of it does. So if you're working in one of these other areas, some of it may apply, some of it won't. Water utilities are probably the closest in terms of how they're treated. Resources, the main resource is going to be the PUC's website. The PUC's website has a massive amount of information on it, which is very useful. And pretty much everything you need will be on there. Finding stuff on there is a challenge. So I'm going to give a quick intro to finding stuff on the website. You'll go to the homepage of the PUC's website. It currently looks like this. They recently changed the photograph, but otherwise the layout has stayed the same. There's a lot more material on the homepage as you scroll down from that. And what you want to do to get the place where probably 90% of the most useful information is scroll all the way to the bottom of that homepage. And at the bottom, you'll see this menu. And on that menu, you'll see the thing I have circled here, Proceedings and Rulemaking. I don't know why it's located there. I don't know why it's called that, but under that is where you'll find the most useful information as a practitioner. If you click on that, you'll get this page. And you can see this has a number of things that are useful: daily calendar, how to e-file, get involved, decisions, etc., practitioner's page. The two things that are probably going to be the most commonly used for you are the docket card. The docket card shows everything that's been filed in a formal proceeding, rulings, pleadings, everything. So if you're trying to figure out what's going on in a proceeding to build a new transmission line, what's happening with Diablo Canyon, what's happening with the Renewable Portfolio Standard, resource adequacy, if there's an open proceeding, there'll be a docket card and it'll have all of the filings in that, so you can tell what's happening in the proceeding and where it is in there. The other one is locate documents, and this gives you a more refined search. The search at the top of the homepage is like a Google search and will give you everything in the universe. Locate documents, if you're looking for a decision, a resolution, something specific, that's where you can find it. Then if you scroll down on this page, on the Proceedings from Rulemaking page, get down to the bottom of that. This is the very bottom of that. They have another location for this search where you can search for things, which is nice. The two things they have circled is Public Utilities Code, which is a state law governing the PUC. That's a link to the legislature site, so it's going to be updated. So you can find the relevant code sections there, including my personal favorite, which is Public Utilities Code Section 701, which essentially says, yeah, the PUC can do that if it has jurisdiction. The other thing that's very, 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 very important, did I say enough varies? Probably. Very important for you to find and to know and to look at are the Commission's rules of practice and procedure. They are, the rules are not actually bad. They're relatively simple. They allow for a fair amount of flexibility. You have to know those rules. The Commission does not follow the APA. It has its own rules. And the rules are going to be different than they are in courts. So just because you know the rules of practice in Central District Federal Court in LA or State Court or APA, read the PUC's rules of practice and procedure. They're not super long, so just have those at hand and you can get to them through that link. Let's jump from that to the structure of the PUC. The PUC is a commission. It has 5 commissioners. The 5 commissioners are appointed to staggered 6-year terms. They're appointed by the governor. There are no specific qualifications, background, anything for that. They do not have to be members of a particular party. They do not have to have any experience in utilities. It's whoever the governor wishes to appoint. The current crop actually does have an unusually large amount of experience at the commission. There are 3 commissioners who formerly worked at the commission as staff at various levels. And there's another one who has worked in other government energy agencies. So they actually have a fair amount of background. Under the commissioners, the commission is divided up into divisions. And divisions kind of fall into a number of different categories. There's what's called the industry divisions, sometimes called advisory or technical divisions, which would be like energy division, water division, communications division, and so forth. Those divisions are largely supporting the commissioners and administrative law judges in proceedings and in doing other work. They are typically not going to be a party in a proceeding. There are advocacy divisions, such as the Public Advocate's Office, Safety Enforcement Division, and so forth. Their role is to show up and to litigate in PUC proceedings. There are some that don't fit into either of those categories. The Administrative Law Judge Division, all of the ALJs, and a lot of their support staff, docket office, process office, etc., are in the ALJ division. Legal division has kind of two hats, kind of corresponding to the industry divisions and the public advocates. They have an advocacy side and they have an advisory side. So the advisory side does what it sounds like, provides legal advice to the commissioners, ALJs, technical staff, whoever needs it. And the advocacy divisions will litigate, most typically at the PUC. They will be representing people like the Public Advocate's Office or Safety Enforcement Division in proceedings at the PUC. There is an executive director of the PUC. In the past, the executive director's office was essentially just kind of in charge of the administration side of things and was not really involved in the substance of what the PUC does. This has shifted over the last number of years, and there are now deputy executive directors who are slotted in between the commissioners and the divisions. So this has created a more top-down structure. You can have whatever opinions you have about whether that's good or bad, but the executive director's office and the deputy executive directors now have a larger role in the substantive work of the commission than they used to, in that kind of being a go-between between the commissioners and the divisions. If you're an intervener in energy proceedings, that is, if you show up, if you decide you want to participate in a formal proceeding, you would be an intervener. And when you show up to do that in an energy proceeding, here's who you'd most interact with. You would obviously interact with the administrative law judge. All formal proceedings at the PUC have an assigned ALJ. In most cases, the public advocate's office will show up. Again, they are representing typically kind of residential, small business consumers. They're essentially the consumer advocate's office. Used to be called Division of Ratepayer Advocates or Office of Ratepayer Advocates, and now called the Public Advocate's Office. They will be in most cases. Legal division, there will be someone from legal division representing the Public Advocate's Office. So if the Public Advocate's Office shows up, chances are there'll be a lawyer from legal division. Energy division may or may not be there depending on the type of proceeding. They will not be a party. They may do some things to provide some input, especially in a rulemaking proceeding. They may do a staff recommendation. There may be some sort of report, but they may be around. And if they're not around, they'll often be in the background. Other characters who you'll run into outside of the PUC, you will obviously run into the utilities. Most proceedings, pretty much every proceeding, is going to involve one or more utilities. It could be a utility asking to build something, asking for a rate increase, asking to do something. There can also be rulemakings where the commission is changing rules, in which case you'll have more utilities are affected by the potential rule change. You will have other interveners. There are groups that regularly show up at the PUC, consumer groups, environmental groups, industry trade groups, large customer groups, competitor groups, local governments. They will frequently show up at the PUC. Some of the very experienced farmers, agricultural, utility unions are very active participants. Sometimes there are outside entities who usually will not be a party to a proceeding, but their work will affect the proceeding or may interact with the proceeding. So FERC, Federal Energy Regulatory Commission, CAISO, the California Independent System Operator, CEC, California Energy Commission, they typically will not be a party in a PUC proceeding, but their work will affect the PUC's work and can have an effect on the proceeding. So you should need to be aware of their existence, and ideally you'd know what they were doing, but there's a lot to keep track of. There are entities who may interact with the commissioners, but typically will not interact with you or show up in the proceeding, because they will just call the commissioners to tell what they think. The governor's office, legislators, sometimes Wall Street or rating agencies will communicate, typically outside of the proceeding, which can sometimes be confusing because suddenly things may happen that you didn't know were going to happen for unknown reasons. Okay, let's get into the nuts and bolts of formal proceedings. You do not have to dress this way, especially online. You can continue to wear your fuzzy slippers if it's online. But this is formal proceedings as opposed to informal proceedings. There are 4 types of formal proceedings: application, rulemaking, investigation, and complaint. As an intervener, someone who's interested in stuff that the PUC is doing, chances are most likely you will be showing up to an application or a rulemaking. It's less likely you'd be involved in an investigation or complaint. A little housekeeping thing here. All formal proceedings have a case number, a proceeding number assigned to them. So if you're going on the docket card to find a proceeding, the way to do it is with the proceeding number. Although on the docket card, you don't need the dashes and periods, and you don't even need the letter. But it's actually a pretty logical system. You have the letter in front, tells you it's an application. A, it's an application. 16 that tells you it was filed in 2016. 8, it was filed in August, and number 6, it was the 6th thing filed in that month. Something was filed, an application was filed this month, it's July, so it'd be 2507, whatever number it is. So that's the numbering system. With that, let's go into application. What's an application? How does it start? So an application is filed by the utility. That's how it comes in, that's how it's opened at the commission. The utility will file an application. And the utility will file an application typically because it wants money. The utility will be proposing to do something. That could be undergrounding a bunch of transmission lines. It could be building a new transmission line. It could be changing its rate structure to increase its fixed charges. It could be approval of a large contract. It could be a proposal to retire a nuclear power plant or a substation. The reason they're filing it is because there will be a cost involved. And for them to recover their cost, they need commission approval of that cost, that rate change, to recover the cost and rates. So it will be the utility coming in, proposing to do something, and it's going to add something to rates, typically. It could subtract in rates, but that's less common. Why would you get involved? The main 2 reasons people get involved as interveners in applications are they either dislike or like what someone is proposing. The new transmission lines go through their front yard, or maybe they like that it's going through someone else's yard and they're showing them to make sure it stays there. Or they don't like something the utility is proposing to close a customer service center. Whatever it is, if you don't like what the commission is being asked to approve, the utility is proposing, you may want to get involved. The other reason people get involved is could be a rate increase where the utility will be asking for more money. Sometimes they'll ask for a lot of money, and you don't want to pay that in rates. Certainly, a lot of the consumer groups will get involved that way to oppose significant rate increases. There are a number of steps in the typical application process. Let me break these down a little bit more because there's just a list of things. It starts with the application. The utility files the application. The next thing that happens is anyone who is interested in participating in it and anyone who is opposed to it can file a protest or a response. Protest is the one where you say, no, I don't like what they're proposing. Response is saying, I'm not opposing it, but I'm interested in it. Those need to get filed within 30 days from the date that the application is filed. Once those are filed, the commission, usually the ALJ, will hold a pre-hearing conference, which is essentially housekeeping. Who are the parties? What are the issues? What's the schedule? Do we need evidentiary hearings? After the pre-hearing conference is held, the assigned commissioner, because each case will have an assigned commissioner, will issue a scoping memo that sets out the scope, the issues in the case, and the schedule. After that, there will be testimony. And let's assume there's evidentiary hearings in this case and briefing. This is where things get very different than a court case. All direct testimony is served in writing. It's not spoken directly from the witness stand. This is because a lot of times it's very voluminous. It may have a lot of numbers and technical appendices, spreadsheets, calculations, and so forth. And you really, really don't want to sit there and listen to someone walk through and recite this on the stand. So the direct testimony is in writing and is served. Evidentiary hearings, this is again very different from a court proceeding because you could have multiple parties. There are certainly cases I presided over where I had 20 parties, something like that. And everybody, if they want to, can submit testimony. Usually not everyone submits testimony, but you can have multiple testimony. And then what happens at the evidentiary hearings is the sponsoring witness for the testimony is cross-examined. So you could have 12 parties testimony, and so you'd have the 12 witnesses, and maybe you'd have 20 parties who want to do cross-examination. So you'd have multiple parties cross-examining the testimony of multiple other parties. Managing that can be an art form. Sometimes the evidentiary hearings can drag on. If they're well run, it doesn't have to. That varies in terms of how efficiently they go. But you can have multiple parties cross-examining other parties. After hearings are done, parties can do briefing, and that's where you make your legal arguments. You draw from all of the pleadings that have been filed, the testimony that's in there, that's in the record, and the cross-examination. That's when you make your legal arguments. You don't have to file testimony. I strongly recommend if you're actually participating in a case and want the judge to go your way, you should definitely do briefing. You may do cross-examination. You can decide whether you want to do testimony. One thing to remember is if you submit testimony, your witness will be cross-examined. And so you need to be prepared to have your witness be cross-examined. Briefing, middle parts. So you've gotten a legal briefing, getting towards, oh yeah, here's what I was just talking about. Multiple parties, written direct testimony, cross-examination. When you get to the end of the application process, what'll happen is after the briefs are filed, the assigned administrative law judge will write and issue a proposed decision. It's not a final decision, it's the ALJ's proposed decision. That will get sent out to the parties for comments. Typically, you'll have about 20 days for comments on the proposed decision. It's a useful time to point out any mistakes or errors or omissions in the proposed decision. Just trying to re-argue things that you lost usually doesn't help, unless you can figure out some way that it was just a real mistake that the judge made. And sorry, just ruling not your way is not necessarily a mistake. Once the comments are in and any modifications are made to the decision based on the comments, it goes on the agenda of the commission. And if the commission votes it out, that's the final decision. And so that becomes the decision of the commission. So, but until they vote it out, it's not a final decision. Let's go to rulemaking. I just put up here these things to scare people in terms of how complicated rulemakings are. But the good news is none of these are the PUC's rulemaking process, and I don't have a flow chart for it. It's actually can be simple. Some of them get more convoluted as time goes on. These start in a very different way from applications. Rulemaking starts with a commission order opening a rulemaking, order instituting rulemaking, or OIR. Commission loves acronyms, you'll get used to them, or you'll tear your hair out, which is how I don't have as much as I used to. But an OIR, order instituting rulemaking, is issued by the commission. It will typically name all of the utilities in a field, all the energy utilities, as the respondent. And it is used for changing rules. When the legislature passes a new law, such as they passed the requirement for the renewable portfolio standard, they said, okay, PUC implement it. So the PUC had to come up with rules. They opened a rulemaking to come up with the rules for how you manage the renewables portfolio standard. Commission decides they want to change the rules for the configuration of overhead lines, the safety requirements for overhead lines or underground gas pipelines, and they're going to change the rules for that. They will open a rulemaking. Why get involved? So typically these will not directly, in general, not 100% of the time, but in general, these will not directly result in a rate increase. So you typically won't find people jumping in because they're worried about a rate increase because they won't directly result in a rate increase. It's, do you care about the topic that they're looking at? Do you care about renewable energy or resource adequacy or undergrounding of lines or safety rules for gas pipelines, whatever the rule is that they're looking to change. If you care about it, and you care about how it comes out, you may want to get involved. Again, here's a list of steps. So there's the order instituting rulemaking, and instead of protest, or let me see what I have in my next slide. Instead of a protest or response, parties are invited to file comments. Again, there'd be a pre-hearing conference. There'd probably be a scoping memo, which I didn't list on here. There may be a staff report or workshops. There may be more comments. At the end, the process is the same. The middle process can vary. At the end, it becomes the same. There's a proposed decision, goes out for comments. When the commission votes on it and approves it, it becomes a final decision. Here are the parts that are different than an application. A lot of times more time in rulemakings is spent on written comments rather than evidentiary hearings. It's possible they'd have evidentiary hearings in a rulemaking, but it's less common. Usually they're getting comments, sometimes multiple rounds. There may be a staff report. So in other words, they have an idea for how the new rule is going to look like. And Energy Division will issue a report and say, here's what we thought about it on. The other thing that's often used in rulemakings are what are called workshops. That's when the parties, and usually something like Energy Division staff, technical staff, can get together and discuss issues. This can be very useful in, figuring out where people stand on technical issues, making sure there's common definitions. Not every rulemaking uses workshops, but it's a tool that can be used, that can be helpful. And usually that's one of those things that's discussed at the pre-hearing conference, whether there should be workshops or not. So the application process usually is pretty similar. There's not a lot of variation. The rulemakings can vary more, just depending on the nature of the rulemaking, how contentious it is, how technical it is, et cetera. So you may have hearings, you may not have a staff report, you may or may not have workshops. So there is variation in the rulemaking process. Investigation. Let's see. Investigation. So this would be, how does it start? Again, it starts with a commission order. In this case, an order instituting investigation, or OII. This is most commonly used for things where the commission is thinking of imposing a penalty on a utility for something it did wrong. So when PG&E blew up part of the city of San Bruno or burned down the city of Paradise, SoCalGas had their major gas leak at Aliso Canyon. The commission will typically open an OII to then consider what happened and possibly impose a penalty. There are some that don't involve a penalty. The PUC opened one into PG&E safety culture, just essentially like asking the questions like, what's going on with PG&E? We keep hitting them with $2 billion penalties and they keep screwing up anyway. What's up with their safety culture? So that one did not have necessarily a penalty at the end, but was looking at a broader question, but a utility specific question. Why get involved? You're less likely to get involved in one of these things. There are people who will intervene, certainly when the city of San Bruno showed up in the OII going after PG&E for city of San Bruno. They may be interested in the remedies that are imposed. So it's usually, because it's a more focused thing, and it's usually not going to result in a rate increase, fewer people get involved in it. The process, so for example, in a case like Aliso Canyon or San Bruno, commission safety staff will do an investigation and will issue a report on what happened. Once that report is complete, then the order instituting investigation will be opened. And so there may be a delay. There's usually some delay between the event that triggered the investigation and the order instituting it, because staff will often have to complete their investigation. In case of wildfires, often staff has to wait for CAL FIRE or the Forest Service to do their preliminary investigation. Then the staff will look often at what the utility did, and then there will be an order instituting investigation, then pre-hearing conference. Scoping memo, again, written testimony. There will usually be hearings. Slight difference at the end, you'll get what's called a presiding officer's decision and a final decision, not a big deal. I'm going to pause briefly. I've seen a couple of questions pop up. I haven't seen the questions. Marisa or Jason, are there ones that are like short questions that I can answer, or should I wait till the end?
I think there's a couple. Let's see. Holly Carter said, is there opportunity for G2G in any / all of these proceedings? I'm not sure what the G2G stands for, so maybe she can type in what the acronym stands for. And then Courtney Coyle wrote, oh, government to government. And then a second question is, I work with California tribes. How time intensive / costly is it really to intervene? So I think you may be getting into intervener comp later, but if either of those questions you
Yeah.
want to answer now.
Yeah, let me do the second one because that's a good question. How costly and time intensive it's to intervene? You can somewhat tailor it depending on how much you want to do. So in other words, you can intervene and not do a lot. You probably won't be necessarily as effective. You'll have to spend some time monitoring the proceeding and keeping track of what's going on. But you don't necessarily have to prepare a written testimony. You don't necessarily need to do cross-examination. You could just write a legal brief and go with that. So you can generally try and adjust it. If you are fully engaged in the case, and it also depends on the case. Some cases drag on for a long time with a lot of parties that are very contentious. And if you're really fully engaged, it can be very time consuming to do that. And then if you're paying a lawyer, then that makes it very expensive. But you can generally tailor your level of participation to what your resources are. Certainly when I worked at Turn, we would adjust because we were short on staff when I was at San Diego. G2G, this is sort of a different process. So there's a little mismatch there with the question. So I'm going to not answer that one just because I think it's a longer discussion. So, but those are good things. Let me go ahead and go to the next part. Complaints. Parties can file a complaint against a utility. It can be a customer that files a complaint, could be a competitor, could be a member of the public. So the complaint is filed against the utility that the utility did something wrong or failed to do something like that. The commission will usually try and encourage people to try and informally resolve these before filing a formal complaint, but that's essentially what it's used for. Typically, these are pretty narrow types of things, so other people will not intervene. It's rare to have interveners in complaint cases. It's possible, but if you see the docket that starts with a C, it's a complaint. Okay, this is another layer, and initially it'll be confusing because in addition to the types of proceedings, application, rulemaking, investigation, complaint, every proceeding is given a category. It's categorized. And there are 3 categories. So there's 4 types, 3 categories. So just to make things a little more complicated. Not bad once you understand it. Until you understand it, it's confusing. Rate setting, quasi-legislative, and adjudicatory. And I'll address these backwards. Adjudicatory is most like a court proceeding. It's that would typically be like 2 parties fighting. Most investigations are adjudicatory. Quasi-legislative is like the legislature, and parties will show up and can lobby and so forth. And rate setting is what it sounds like. The commission's doing something that's going to result in a rate change. why do you care about what category it is? It's like, why does it matter? And there's two reasons why it matters. One of them is the ex parte rules vary between each type of proceeding. Who you can talk to, do you have to disclose it? What are the requirements about that? If you want to meet with commissioners, can you do it? The other difference is who controls the first decision. So in some cases, the ALJ's decision, whatever the ALJ wants to write, will get out the door, and that's the first decision that's assumed. In other cases, the assigned commissioner will determine what the will write, or at least be the author of the first decision. So that's why you care. Rate setting, almost all applications are rate setting because typically they're filed because the utility wants to increase or occasionally decrease rates. It's possible that some rulemakings will be rate setting if the change in the rules has an associated rate impact. We're going to now require all vehicles to have, I don't know, a telephone pole strapped to their top, and we estimate it'll cost X dollars, and the utilities are authorized to recover that cost. If the rulemaking is going to result in a rate increase, it should be considered rate setting. Rarely investigations. Rate setting is the default category. If they're not sure what to categorize a proceeding as, or it could fall into more than one category, it should be categorized as rate setting. It doesn't always happen, but that's where it is. Quasi-legislative applies to most rulemakings. It's very unusual for anything else to be under quasi-legislative, because rulemakings are kind of like a quasi-legislative activity. But it's unusual for anything else to be quasi-legislative. And adjudicatory is going to apply to most investigations where it's, the commission going after utility going to impose a penalty, or a complaint case where someone is fighting with the complaint. When it's most like a court case with two parties fighting about something, it could be adjudicatory. It's very unusual for it to apply to a rulemaking or an application. Almost never applies to that. Ex parte, we will talk about what it is. The rules are different depending on whether it's rate setting, quasi-legislative, or adjudicatory. This is all in Rule 8. So if you have the rules of practice and procedure, go to Rule 8, read it. And again, I'll run this backwards. Adjudicatory, like a court case, there are no ex parte proceedings. You cannot call up the ALJ or the commissioner and explain how you want the case to come out on a substantive thing. You can communicate with an ALJ and process things. It's like, when does this brief due? Can we change a date? Things like that. But there are no ex parte communications allowed in adjudicatory cases. In quasi-legislative proceedings, again, it's kind of like the legislature. You can lobby. So if in your quasi-legislative proceeding, if you can get access and have a meeting with a commissioner, you can talk to the commissioner. You can talk to their advisors. You can talk to the LJ, tell them what you think, etc. No limits, no reporting. Rate setting is in between. You can have them, but there are reporting requirements. Typically, if you're going to have an ex parte meeting, you need to do notice in advance. And after the ex parte meeting, you have to do a notice that describes what was communicated. I often found these reporting requirements of limited utility in terms of understanding what another party said. PG&E met with the commissioner and we expressed concerns about the proposed decision, right? They don't necessarily tell you what went on and know how to respond to it. Adds extra burden, which mostly benefits the utilities who have a larger staff who are available to do things like file ex parte notices. But Rule 8 describes it. Ex parte meetings, ex parte under their definition, can occur anytime during the course of a formal proceeding. So once an application is filed or an OIR is there, they're in place. Most common time is what happens is the ALJ issues their proposed decision. Someone doesn't like it, and they're going to be asking for ex parte meetings with the commissioners to try and come up with a different result. Not yet final decisions. This is stuff that has not been voted out yet. In a rate setting case or in a quasi legislative case, the ALJ will draft a proposed decision, which will go out for comment. If one of the commissioners wants a different result and cannot persuade the ALJ to change their decision, one or more commissioners can issue what's known as an alternate decision. So you could theoretically have a proposed decision and 5 alternates. I don't think that's ever happened. There have been a proposed decision and 2 alternates. Most often it's 1 alternate. Those decisions, the proposed decision, the alternate decision, will both go before the commission at a voting meeting, and the commission will then vote out one of the decisions. They will vote out either proposed decision or the alternate decision, which then becomes the final decision. In an adjudicatory proceeding, it's a little bit different. There will be a presiding officer's decision. Most of the time, not all the time, but most of the time, the presiding officer will be the ALJ. So the ALJ will issue the presiding officer's decision or the pod. If none of the parties appeal, they can do an appeal of the pod, or a commissioner can do what's called a request for review of the pod. If neither of those is submitted, the pod will eventually automatically become the commission's final decision. The commission doesn't have to vote out as long as no one asks for a change. If a party appeals the pod, or a commissioner does what's called a request for review because they want something different, the presiding officer will issue a modified presiding officer's decision, sometimes called a mod pod. And then that would go on to the commission's agenda for adoption. There is a thing called a decision different. Sometimes it's called that in the rules, sometimes it's called a different decision, somewhat unclear, but essentially it's essentially the equivalent of an alternate to a pod. So again, the commission could have a choice of voting out the pod or mod pod or another commissioner's decision different. When does a decision become final? These are the commissioners when they voted out. These are the commissioners. So Matt Baker, Darcy Houck, and John Reynolds had all worked at the commission in various positions. Karen Douglas, on to the side, has been involved in energy stuff in the state for a long time. Final decision. So yeah, when the not yet final decision voted by the commission or a pod, that's when it's final. What happens after the decision? Can you do stuff after the decision? What if you don't like the decision? So if you believe the decision made a legal error, that there's a legal error in the decision, you can file an application for rehearing. If you're a party, so you have to have been a party, you have to have been participating. This would be another reason to possibly become a party, is this gives you the ability to file an application for rehearing. And you file the application for rehearing saying there was a mistake in this thing. That goes to the commission, does not go back to the LJ, it goes to legal division. There's a rehearing section in legal division. The attorney there will review the application. Other parties will get a chance to respond to the application for rehearing, and they will then write a decision on rehearing that goes before the commission. That could either grant rehearing, it says, yeah, there's a problem, let's go back and do something over again. That's very rare. Usually what they do is they clean up and fix anything they see in there and say, yeah, well, if we kind of tweak this a little here and change this language here, we find there's no error. And here's the decision on rehearing that says what the commission did is okay, and we're done. If you don't like the decision on rehearing at that point, or there's also a time way to do it, you can then try to do a writ or appeal. They used to all go only to the Supreme Court on a writ. There was legislation that changed that a while ago so that most of them will go to the Court of Appeals. Last I checked, the only exceptions were water cases and CEQA cases that still went to the Supreme Court. partially because of, I think, one thing was intentional and one thing was accidental. Separate thing, petition for modification is a little different. So the commission puts out a decision, and then at some point later, facts on the ground make it harder, or there's a problem, or someone realizes they don't like it or whatever. It's not legal error, but there's need for change. The commission orders PG&E to paint all of their trucks pink. 2 years down the road, it turns out there's a worldwide shortage of pink paint. They can no longer get pink paint, and so they might file a petition to modify to please ask that they can paint their trucks green instead. All of these are in Rule 16. Again, Commission Rule of Practice and Procedure, so you can find information on these in Rule 16. Intervenor compensation. If you are an intervenor and participating in a case could prove to be a financial hardship, it is possible to get intervenor compensation. Essentially, what you would do is you can file a notice of intent to claim it, and then you might be able to get paid for it. You have to show hardship, you have to make a substantial contribution, and you have to wait. So you might be able to get paid, maybe, but it'll take a while. It's paid after the fact. You don't get anything up front. So then that's a whole separate topic for other conversation, but it does exist and it is statutory. How to become a party in a formal proceeding. This goes to the question earlier, how and how much do you want to participate? Do you want to participate? Do you want to become a party? Do you just want to keep track of what's going on? No one's going to invite you to be a party unless you're a utility receiving a rulemaking or investigation. The best way to do it is to file a protest, because if you file a protest to an application or response to an application, you are automatically a party. You're in the case. Likewise, comments in response to an OAR, you're in the case. The downside is those have to be done early. You have 30 days typically to file one of those things to become a party. Next thing is you can show up at the pre-hearing conference and make an appearance there, state your name, express your interest, talk about how you're going to participate. In general, that should result in you just being made a party. Occasionally, if you don't have a clear reason for participating, or you're not sure you're actually going to participate, you might get shunted off into a thing called information only. But if you want to be a party, you can do it then. If you don't make any of those things, you can also submit a written motion for party status. And once an ALJ rules on that, you can be made a party. Again, this is in the rules. Rule 1.4 governs how to become a party. So this is how you get into a proceeding. Again, you can choose. You can do a protest or response. You can submit testimony knowing that there's work in doing that, and you may be cross-examined. You can submit comments, especially in a rulemaking. You can do cross-examination. You don't have to. And you can do briefing. I recommend, if you do nothing else, briefing is good because it's close to when the ALJ is writing the decision. You can draw on everything that happened before that. And so if you're trying to minimize your time and effort that you put into it, at least do the briefing. Usually protest up front is good. Statement something at the pre-hearing conference is good. And then if you want to do cross-examination because you need something for your brief, do that. I often did that when I was at San Diego or Turn. I figured out what I wanted to argue. I do cross-examination just enough to get the stuff I needed to support that argument, and then do the briefing. There are settlements. These cases do settle. Look at Rule 12. Because you'll have multiple parties and multiple issues, it's common to have settlements that are only some of the parties or some of the issues. That's a possibility. The commission does have ADR processes, most typically mediation. You would be assigned a mediator, an ALJ, not the ALJ hearing the case, as a mediator. That's free of charge. Some of the mediators are very experienced and very good. Motions are the catch-all. You want the commission to do something, you're asking for something, you'd file a motion under Rule 11. So settlements Rule 12, motions Rule 11. The requirements are not that hard. Other proceedings, this is a little hard. There are things that happen at the commission outside of formal proceedings: advice letters, citation, administrative enforcement orders, administrative consent orders. The commission can do things outside of a formal proceeding. It is much harder to follow what's going on in those things because there is no docket card. And they will often then ultimately be approved in a resolution because their commission does something, but then the commission needs to approve it. It will get approved in a resolution. The problem is that sometimes the first time you realize something's going on is when it pops up in the commission's agenda in the form of a resolution, and you realize it's like, wait, how did they get there? But that's a whole nother topic. Let's see. That's what I've got prepared. So let me one thing. Part of the proceeding, here's a bunch of online resources. This has some of the links I shared. There's some other resources on there. So that's something to keep in mind. That will be part of the materials. We'll do these online resources. I think, are we good on time for some questions now?
Yes, I think so.
Should I stop sharing my screen now? Should just go to the, doesn't matter.
I think questions is fine. Or if you'd like to, I guess if you don't show the screen, then people can see your face. But thank you so much, Peter. That was wonderful, and you really covered a lot and gave people a good roadmap for how you get involved and all the different parties and players. Susan Wilson had a question. She says, why do you say, quote, vote out? I've heard many CPUC practitioners use this term, but never understood why. And there actually is a vote, but I'll let Peter answer that.
Basically what'll happen is when a proposed decision goes up before the commission, they will essentially vote on whether to adopt it or not. And so each commissioner will say yes or no on that. So it is like a vote. And most decisions get voted out 5-0, but it is possible, especially when there's an alternate decision, that there may be a split, and it may go literally voted out 3-2, that they will take roll of the commissions. How Commissioner X, how do you, yes or no? Commissioner Y, yes or no? So the commissioners literally vote out each decision that comes on the agenda before them.
And those are public, available online. You can generally watch the video. So the calendar for the meetings of the CPUC commissioners, they have the agenda, and I think Peter mentioned some items will be on consent, so they don't discuss them, and then others, there is discussion and the public can participate, and then they really, they are sitting up there on the dais and they actually do vote.
Yeah, it is a public meeting. The commission, the official meetings where they're adopting the decision, voting out the decisions, are public meetings and publicly noticed. They're typically 2 per month, except for, I think, August or maybe December. I think August they don't have, I think they might only have one.
And then Peter, I didn't know if you wanted to circle back to the government to government question. Just from my perspective, there can be multiple government entities serving as interveners in a case, and certainly, the commission is a government agency itself. So not quite sure what the question is getting at, but you may have some.
Yeah, I mean, the thing that's interesting is with the commission is that they're a specific agency with a pretty narrow purview, right? They're a regulatory agency. And so it's not like you would think of as a regular government to government thing with the PUC, because I think the PUC doesn't necessarily, even though it's a public governmental agency, I don't think they think of themselves as a government. that would be more likely be the governor's office. And the other thing is the PUC has these very specific processes set up for doing things, right? Which is kind of a litigation-based process. So it's more like you're dealing with a court or maybe a legislative committee than a typical government. So I don't think the PUC necessarily thinks of itself as engaging in government to government. Certainly as a tribal entity, sovereign entity, you're free to try and talk to the commission and commissioners. They will have their ex parte rules, and that would apply to other governments. So certainly, local governments, county governments are subject to ex parte rules in formal proceedings. There are no limits on having communications with the commission about things that are not in a formal proceeding, but they don't necessarily do anything that way. I mean, one thing that's interesting now is they do have open the tribal OIR. So certainly that would be something that if members of a sovereign tribe wanted to have a conversation with the PUC, you could do that. And I think, last I checked, I think it's quasi-legislative, which means there are no ex parte rules on it. So that's available. I hope that sort of answers the question. I'm not sure it's a perfect fit for the question, but.
Thank you. Jason, did you have any other questions for Peter? If we do have a couple minutes, we can end early, and Peter let us know he has much more content, could do a whole nother hour of maybe a 2.0, getting into other nitty-gritty of CPUC practice. So if there's interest, we could do another session. But yeah, I'd just love to hear real briefly about your work with the tribes. And then Jason, I don't know if there was any other questions you had that he didn't cover.
Yeah, thanks, Marissa. So this may be better covered for maybe potentially another series, Peter. But could you speak a little bit about I know there's no discovery per se and PUC proceedings, but there are data requests, and maybe the practitioners may want to know how they can go about getting some information to rebut what utilities are arguing, et cetera.
That is a good question. Sorry, I did not address that. There is form of discovery, and at the PUC, it's generally called data requests. 90+% of the time, you can submit a data request. Usually, it's asking for the other party for documentation of something. So certainly, interveners can ask data requests of the utility. They can ask for information. They're submitted in writing. There are occasionally depositions. It's unusual, but depositions are done. It's generally less formal and less contentious than it is in civil proceeding, which is part of the reason why I started doing this. Was I was doing civil litigation and I hated discovery fights. It was just like, oh, this is just painful. And so it's usually less contentious, in part because commission staff, like the public advocate's office, has statutory discovery rights against the utilities. So the utilities have to provide stuff to the public advocate's office under the law. Doesn't mean they won't necessarily fight certain requests, and certainly privileges apply and so forth. But it means that a lot of the stuff is going to get out there. And so, but it's a more informal practice. It's generally done in writing, generally not depositions, generally not, like requests for admissions or things like that, although those are occasionally used. So there are discovery opportunities. It is more informal. What you can do as an intervener is sometimes try and tag along with other people or requests. For example, if you're a consumer advocate, are worried about rate increases, just try and make sure that you get copies of whatever the public advocate's office gets. And sometimes what'll happen is, to avoid duplicate discovery, because remember, you could have 20 parties doing discovery on 20 parties, which can be totally unworkable. A lot of times what an ALJ will do is basically make it that any responses, any questions and any responses are just served to all the parties, so that you don't get the same question asking roughly the same stuff from 20 people or something like that. Usually doesn't happen that much. Some parties do more discovery than others. And it's usually discovery on the utility, who's usually pretty well equipped to answer it. Sometimes the utility will do discovery on interveners. A lot of times you don't have much to give them. So it's a little different than the civil case, but there is a variety of discovery. It is more informal, usually less contentious than it is in civil litigation. Thanks, Jason. That was a good question. And then, Marissa, you'd asked about interactions. So what I'm doing with the tribes is relatively limited in that Tech has a number of different programs that it's doing with the tribes, including workforce development, helping them with different projects and so forth. And one piece of it is trying to help them build up their policy and regulatory ability to participate policy and regulatory proceedings. And so essentially what I'm doing is kind of what I did today, which is providing training. Also, what I'm doing is kind of providing information to Tech as they try to understand how the PUC works. So I'm doing that, and there's a guy named Steve Moss, who's with M Cubed, the regulatory consulting group, who's doing it. So my main role is essentially doing chunks of this. So I've done little tiny chunks of this training so far for the tribes, and I'll be doing probably a number more on some of the different issues, and then just supporting Tech in making sure they understand how things work at the PUC and how to approach things at the PUC.
Awesome. Well, I'll send out a last call for questions, but haven't seen anything new. And yeah, with that, thank you so much, Peter. I think, as you can tell, PUC practice is very specific. It's right within environmental law, within regulatory law. It's not like regular civil litigation. And there's a lot of jargon and processes and their own rules of procedure to be aware of. So I think you gave us a great overview. And these 101 series are designed to be accessible for newer practitioners, younger practitioners, and even experienced practitioners who maybe don't do PUC and utility work day to day. And so just to learn enough to understand where to find things and where you need to go. And so it's great having someone like you who has been on all sides, right? Government, local government, interveners, commissions attorney, and then as an ALJ. So we really appreciate having you.
Thank you. Glad, and hope this speed run through the basics is helpful. So thanks for having me. Appreciate it.
Thank you so much.